concentrating on the objections raised to the jurisdiction of the court. On that note, the court adjourned for further hearing to 7th of November, when the court expects that he will enter his full defense. Well, having said that, I know a lot of people have raised questions and eyebrows about the propriety of Nnamdi Kanu representing himself. It is his decision to make. He has the right under the Constitution to defend himself, and this case being politically charged, I think the idea or the notion that this is a normal criminal case has to be dispensed with. This is a normal criminal case at all. If you want to understand the complexity of this case and the true political dimensions to it, you think of the case of Nelson Mandela, Martin Luther King, Obafemi Awolowo, Mahatma Gandhi. These cases were all politically tinged cases masquerading as criminal prosecutions. And these great men I mentioned, at some point in their struggle, at some point in their travail imposed on them by the state, they took the podium and defended themselves. So a politically charged case often comes with some unusual dimensions like this. So because why? The reason is simple. Lawyers are restricted to very narrow wiggle room when they are doing a case, and that narrow wiggle room can be inimical, can be prejudicial to the interest of the client when the case has a political dimension to it. That thing needs to, the defendant himself will make the best defense of his case at that very point in time. That does not obviate the fact that the presence of a lawyer in a case is always better, but in certain circumstances there are exceptions, and the exception is this one is one of the major exceptions. Thank you.
Thank you very much.
Thank you very much. Thank you.